hearing of the comprehensive zoning ordinance. That's what that is 12 minutes. What will be your presentation?
Yes, sir. County planning and zoning staff has had the opportunity to review all the proposed oil and gas ordinances provided from various groups and offer the following comments. What I'd like to do, if I may, we kind of broke our own rule and personalized one of these ordinances. I need to change that, if I may. We're going to call them ordinance 1, 2, 3, 4, and 5. You have the lists in front of you on this step. Ordinance 1 was completely reviewed by the New Mexico Office of Oil and Conservation Division, OCD. OCD staff determined that the draft is void of preemptive issues. It separates the county into two areas and provides regulations for permissive and conditional use permitting. It is moderately easy to administer, provides guidance related to land use issues, municipal and tribal notification is provided for. I would also note that you have an email that we sent to you, and you have a copy of before you from OCD that discusses the Citizens Working Group science draft, and does indicate that there are some preemptive issues involved in that ordinance. Ordinance 2 is a draft that was reviewed and recommended by the Planning Commission. The County Commission has also reviewed the draft. It is a clarification and streamlining of the OCD review draft. It is easy to administer and void of preemptive issues. Ordinance 3 is a combination of both the Ordinance 1 and Ordinance 2. It separates the county into two areas and provides regulations for permissive and conditional use permitting. Municipal and tribal notification is provided for. It is easy to administer, but may have one preemptive issue related to water sampling. I will tell you, I spoke to the county attorney about that, and that may not be that big of an issue. Both Ordinance 4 and 5, both drafts are much harder to administer. Both drafts propose regulating issues that present preemptive problems in relation to both state and federal agencies. Drilling and water issues are most problematic. The ordinance team, I have to call that out, number 4, separates the county into 3 areas and provides regulations for permissive, conditional, and special use. Municipal and tribal notification is provided for. Staff has been consistent in our position that any ordinance developed should, 1, be related to land use and void of preemptive issues, which include all regulations under the ground level. Other state and federal agencies have controlling legislation for underground regulation. Number 2, be clear and easy to administer. Number 3, divide the county into 2 separate areas based on population, geography, and hydrology. Number 4, provide for a permissive and a conditional use permitting process. Permissive use zoning requires no public notification. Public hearing, conditional use does require for public hearing. And number 5, provide for tribal and municipal notification. Staff has been consistently concerned that the draft ordinance should be strictly tied to land use issues from the ground up. The draft should be void of issues related to actual techniques of drilling and regulation of water use protection. These issues are already regulated by various state and federal agencies. For this reason, staff is recommending that the P&Z Commission focus on Ordinance 3, as it meets all of the staff's recommended criteria for an ordinance and has only one preemptive concern to look at. That's all we have, Mr. Chairman.
Questions?
Mr. Chairman, may I have the floor?
Yes, sir.
Mr. Chairman, I'd like to thank you. Mr. Chairman, I'd like to make a couple of comments in response to those made by the director. First, First, with regard to the OCD, we keep hearing that the OCD has preemption problems with some of these statutes. And there was a reference to an email from Allison Marks, an attorney for the OCD, in which the director characterized that as indicating there were preemption issues. The only relevant paragraph of that email that I see is on the second page. It's the fourth from the bottom, and it says, quote, "As a matter of course, areas over which the OCD has existing regulations and/or statutes, OCD would not favor additional regulations, as the OCD already regulates such matters, and we believe we are the best agency equipped to regulate oil and gas development in the state of New Mexico and oversee said laws." That says nothing about preemption. The word preemption does not appear anywhere in that email. And I submit the email does not indicate that the OCD has preemption problems. I would also point out that at least the Science Committee ordinance draft is not an attempt to regulate oil and gas development and operations within the county. It's a land use ordinance under the county's zoning authority. And therefore, I think that the restrictions that are placed on oil and gas development as a part of the county's zoning authority is perfectly legitimate and doesn't create any problem with preemption by the OCD. Now, having said that, the other thing I want to point out is that staff is now recommending that this commission focus on and presumably recommend to the county commission what has now been referred to as ordinance number 3, which has previously been referred to as the block draft. And let me make a comment about that, because the matrix that the Planning and Zoning Department prepared says that that ordinance creates a conditional use for oil and gas development in at least some part of the county. Now let me point out to, I think the members of the commission probably already know this, but perhaps those people in the audience don't know it. Our county zoning ordinance has a definition of conditional use, and it's on page 3 of the comprehensive zoning ordinance, item number 19. I want to read it into the record. It defines conditional, it says conditional use means a use that may be or become a nuisance or hazard to neighboring properties if proper safeguards are not taken. Such uses require individual review and approval by the zoning commission. That's the key. Conditional use has to be approved by this commission. Now let's take a look at the zoning. I seem to have lost my copy of it. I pulled up what has previously been identified as the block draft. In Article 3, the draft purports to create a conditional use for oil and gas development in some part of the county. but I submit it does not follow through. If you look at Article 5 of that ordinance, permit review, the initial section, 5.1 says, the county hereby establishes a permit review procedure for applications for oil and gas exploration and production and the structures and facilities associated with that use. Approval of a request for a permit for oil and or gas facilities shall be granted by the director upon satisfactory provision by the applicant of all the requirements established in this ordinance as stated in Article 5. There's no provision in that ordinance for an initial review by the Planning and Zoning Commission. I would further direct your attention to Article 9, where it says appeal. Anyone aggrieved by a decision of the Planning and Zoning Division Director or designee may appeal such decision to the Planning and Zoning Commission. The decision of the Planning and Zoning Commission may be appealed to the Board of County Commissioners. The implication from that is, I submit, if the director grants a drilling permit to someone and no one appeals it, there will never be a hearing before the Planning and Zoning Commission. And therefore, without Planning and Zoning Commission approval, it's not a conditional use. Therefore, I submit that the block draft does not do what it purports to do. It does not create a conditional use anywhere in Sandoval County. And furthermore, what it does do, it in effect makes all permits subject just to the approval of the director, which is in effect a modified permissive use, exactly what the county commission rejected last January. And therefore, I submit that since the block draft doesn't do what it purports to do, and does what the county commission doesn't want, and further provides for no aquifer protection, it shouldn't even be considered, and it should be rejected. Thank you.
Mr. Chairman, if I may, these issues, I agree with what Commissioner Dang just said. We were going to bring this up if you wanted to consider our recommendation. We're well aware that Section 3.1 of the areas has to be amended before it would be brought to you for action. You cannot take action this evening. Well, what you can do is direct the staff to place an ordinance before you at your next regular meeting for consideration and recommendation. We're well aware that 3.1 has to be cleaned up and areas have to be determined. We have the 4 proposed areas here that we were going to go through with you and are prepared to go through with you and discuss it. Section 5, we understand that depending on what you do in these areas and in Section 3 has to be referred to in Section 5. We're well aware of that. In Section 9.3 under appeals, not only does that have to be clarified, but there has to be a clarification of a stay requirement also. You have a stay requirement in your zoning ordinance right now that basically says when an appeal is filed and accepted by the county, that the action that was taken either by the director or by the Planning and Zoning Commission has to be put on hold until that appeal can be resolved. attorney feels that we need to clarify section 9.3 under appeals also in this. So we agree exactly with Commissioner Dang is saying. We were just going to bring it up if you wanted to consider ordinance 3. That would all have to be done prior to a presentation before you could even take action. The language would have to be noticed and published, or noticed on the web so everybody could read it. But we understand that.
Comments from the commissioner?
Mr. Chair. So now we're dealing with how many ordinances?
5,
Five.
excuse me,
And
5.
and the county commission put forth the public to give us one ordinance. I can't understand how this train got away from us. Can someone explain it to me? And then now you're pressuring us by saying we want you to focus on 3. That's exactly what you said. I can't focus on 3 because now you're going back and saying, oh well, but we have to change it. My feelings is change it and then submit it to us.
That's
Not-
exactly what we would do.
Kind of ask us to approve it now, or approve to use 3 now and have you focus all on 3. That's what I'm getting. Is that what we're trying to do?
No, sir, not at all. We're not trying to force anything. We've made a recommendation after we reviewed all 5.
Okay.
We're saying that we believe number 3 to be the best. We understand that there have to be some language changes in what you've seen to date
Right.
before you can take action. No, what we would do is go in, make the requisite changes, then put it on an agenda for you to review and discuss and potentially vote to recommend.
I'm familiar with that process, but yet I still don't understand why you are focusing on number 3 so much. I guess I'm not,
That's fine.
when it's not right even. I mean, you're going back and saying, I want number 3, but it's not right.
Well, you have a lot of ordinances before you that have been presented to you as is. Staff has not made any changes to any of these ordinances. They are exactly how we've received them, okay? 3 of them have been received from outside entities. 2 of them, the first one, we did, so we know. We worked with OCD on that ordinance. That was presented to you when we very first started working on it. The second one is the one that was recommended by this body to the county commission. That's already been reviewed. Number 3 is a combination of both of those ordinances. It takes ordinance number 2, which was permissive countywide, uses ordinance number 1 and divides the county into 2 areas. Makes it permissive up in the northwestern area of the county, makes it conditional down here in this area of the county. Those would be public hearings and they would be held before this body. Any appeals would go to the county commission for consideration. But we have not changed anything. I understand the frustration. We've got 5 ordinances out in front of us. We think the train got a little off track too. This has been a lot of work for us to go through every one of these ordinances, go through this matrix, try and get all this information to you. Our concern and our reasoning for giving you a staff recommendation is because you can spend months and months and months going through all of these ordinances, going through this matrix, trying to take the language that you like. We think that the citizens working groups, both of them work very hard. We think that they went a little astray from what the county commission asked them to do. We've been consistent through the very start of this process that this is an amendment to the zoning ordinance and needs to be land use. We're getting into things having to do with well drilling, into water monitoring, stuff like that that does not belong in a zoning ordinance. We have been consistent in saying that if the citizens or the public wants to deal with those issues or present to the county commission, then split that out of a land use ordinance. Put it into an engineering ordinance. Somebody who would be qualified to deal with something like that. I can tell you the last citizens working ordinance, I'd have to hire a consultant just to administer the ordinance. That's my opinion. We know what our workload is. We know what we do in the department. We know what our qualifications are. I mean, I'm getting water reports. What would I know about a water report? I don't know anything about a water report. You could show me the chemicals of water. I have no clue what it is. There are preemptive issues. By saying in one of the citizens working group, you can't do horizontal drilling. The state allows horizontal drilling. OCD regulates horizontal drilling, and that ordinance doesn't allow it. There are plenty of problems. What we're trying to do is get you to a place where you can make a recommendation and not have to spend 2 or 3 or 4 or 5 or 6 months going through this process, because you've got other work that's coming to you. I mean, we've been lucky in the past. We don't have a lot of cases. You've got cases coming up. You've got a bed and breakfast case coming up at the end of this month. You've got a commercial issue coming up in September. You've got a noise ordinance coming hopefully in October. We need to get to the zoning ordinance reorganization. We have work here too that we need to do. So we're just trying to, I guess, speed the process along, give you our professional recommendation. We're not asking you to approve anything tonight. What we're asking you to do is to allow staff to work on ordinance 3, get it in legal form, get the proper language in place, and present it to you at your next meeting for consideration.
Mr. Chairman, may I speak?
Hold on, I'd like to ask, I'd like to follow up with Jim.
I'm not through yet.
Exactly, that's
Okay,
what I would like to do.
please let me finish. Okay, Mike, thank you very much. There's a lot of clarification on what you just said. Now, hopefully the public, if you didn't hear any of these explanations in the past, then you've heard them now, okay? You know, I've been working on this for 4 years, okay? Easy 4 years. And that's why you know, all of a sudden, you know, the county commission said, okay, we want 1 ordinance, and now we have 5. And I'm thinking, oh, we're gonna be here another year, okay? So I appreciate you wanting to focus down on 1 and spend some energy on 1, but I sure hope it's gonna be the right one, okay? And I guess that's where we as commissioners have to make that decision, okay? How much time do you think you'll need to pull this together? Number 3, I'm curious. I mean, to rework it, you have to talk to legal staff and.
Depending on the issue, well, understand that 3 is a combination of 1 and 2.
Correct.
They've been 1 and 2 has been thoroughly vetted by legal.
Right.
1 has been thoroughly vetted by OCD.
Right.
It's simply a combination of the 2. Really, there's only 3 changes. 1, it separates the county into 2, which we would need to discuss with these maps. Then it allows for a permissive and a conditional use. We have been proponents of permissive and conditional uses within all of the ordinances that we review. And then it allows for water reporting. It's a water report that comes to the county. We put it on file. Anybody who wants to look at that water report can look at it and determine where to go from there.
Jim, you, like you mentioned earlier, and I hadn't realized it, you're the veteran here. And I would like to know what you'd like to see. You've been doing this for 4 years. There's nothing to show for it.
Yeah, I'd like to see an ordinance that we can actually sit down as a commission and feel comfortable about reviewing. That's what I'd like to see.
Have you had?
I'd like to see the public be happy with that too, and understand that sometimes we have to compromise, all right? And Mike, before I go any further with that, I had a question though, before you asked me. The map, you said create 2 zones.
Correct.
What would one zone contain that the other wouldn't, or what would happen in one zone that wouldn't happen in the other? I'm just curious.
Can I go
Please,
this way?
could I ask that?
Okay, can they hear me? So ordinance 1 is the original map that was done in the very, very first ordinance. Yes. What it shows is that all of the yellow area would be permissive. All of the red area would be conditional. That's how we started it. What we did was all of the outlying lower populated areas would be permissive. All of the higher populated communities, community districts, all of those would be conditional.
Mr. Chairman, could I speak to that, Matt, just real quickly?
Yes, sir, please.
I think, Michael, one of the things that we talk about here too, and for those in the public who have not paid attention to this original map, really all the blue areas are areas where we cannot do any of this, correct?
It's outside of our jurisdiction, correct?
Correct. So I think that's sometimes forgotten in all the chaos. The area that's actually being considered for this ordinance is just yellow and red. And yellow is the private property, correct?
Correct.
And so a lot of this could also be native travel lands, correct?
Could be native.
Travel lands, right, in the county?
And all the native tribal lands are in blue.
Correct. So we're not regulating or doing affecting them at all there.
No.
And then the red conditional, what was the logic behind that?
It's our populated areas. Once I get through with the first map was based solely on population. By the time we get through, you'll see we base it on something else, but it coincides with population. So your hydrology, your geography, and your population are all correlated. Ordinance 2 did not have a map because that was permissive throughout the entire county. Ordinance 3 is this one. What it does is just draw a straight line down through the middle of the county, which basically coincides with the aquifers of the county. Ordinance 4 divides the county into 3 areas. District A is permissive, District B is conditional, and District C is special use. What we want to bring to your attention is the county as it's divided by the USGS. This is a simple map. It's divided by the USGS. They're the federal authority on the geology of our county. There's a very simple map. It happens, if you look at it, it's coordinated very well with population. So it's based up very well with population. Staff recommends this map. It has to be cleaned up. I will let you know. It has to be done by, this is the actual line as identified by the USGS. What we would have to do is go through and pixelate it, if you will. We'd do exactly what we did with ordinance number 4. We have to go by section lines. It's the only way we can do it. So you're either in the section or you're out of the section. Do you apply for a permissive use or do you apply for a conditional use? So that's where we are on this one. So depending on which map you prefer, if this is the route we're going, then we would have to rewrite section 3.1, section 5, and clean those up and then get that to you, and they would correspond to the map that you select.
Thanks, Mike. Appreciate it.
So, again, I wanted to ask you, since you're the veteran of this board, what do you want to see? Which direction you want us to take? What do you think?
Well,
What do you think about the number 3 block ordinance?
I think I would like to see it cleaned up, like Mike is talking about, and I would like to review it at that point, okay? I think, like was said, you know, ordinance 1 and 2 has been vetted, 1 through OCD, 1 through legal staff, so that's gonna get meshed through, I'm sure. That leaves us with 2 other ordinances, you know, the citizen ordinances, and I think, you know, I worked over those. I think there's there are some good things that come out of it. I think we can still mesh. I think we can still bring some things together. I do. I see us making some ground now. Okay, after Mike explained to me some territories, some maps, I'm hearing things that I want to hear as a commission and representing my district. So I feel comfortable. Let's just keep it going, everybody.
Chairman, thank you. Mr. Chairman, the director mentioned the objectives of the county commission, but he neglected to mention the primary objective of the county commission. And I read this at the last meeting. Commissioner Moreno wasn't here, probably wasn't aware of this, but the document which created the Citizens Working Group says that the objective is preservation and protection of drinking water aquifers, groundwater and surface water, and development of a county oil and gas ordinance. Then on the second page, under end product, it says produce a comprehensive oil and gas ordinance that includes aquifer source water, groundwater, and surface water protection. Those are the primary objectives, I believe, of the county commission. And ordinances numbers 1, 2, and 3 don't address aquifer protection at all. There are only 2 ordinances on this list, both created by the Citizens Working Group. Unfortunately, I regret that it's splitted, but nevertheless, there's still a Citizens Working Group in existence. It presented 2 ordinances, both of which exactly fit what the county commission wanted: aquifer protection. And therefore I submit, if we address any ordinance other than the ones labeled 4 and 5, and submit that ordinance to the county commission, we will be giving the county commission something it doesn't want and did not ask for.
Mr. Chair, ask a question.
Mike, what do you say to that?
If I may, Mr. Chairman, section 6.12 of this ordinance, we have copies of it if you want to look at it. Section 1.2, water protection certification. Now, I'm only going to speak to this as it's coming to you as a conditional use. So this is one of the areas that you have to review and you have to consider when making your determination under a conditional use permit. The applicant shall certify that it will comply with the requirements of OCD and NMED concerning the protection of water. It will provide estimates of how much water is to be used, the type of water to be used, where the water is planned to be sourced, and the applicant shall take reasonable measures necessary to avoid the pollution of surface water, groundwater, and the use of non-potable water wherever possible. That language is enough for you to make that determination. If you need additional information, you can ask for that additional information. You can call in OCD, you can call in NMED, you can have them here when you're holding your hearing. You can flesh out these issues. That's a simple, easy, administratable language to use. And it does exactly what Commissioner Adair just said.
Yes, sir, Mr. Chairman. I also want to point out that next paragraph actually deals with testing the water as well. And I think that was something that was a concern of all of us. And I think that's where Mr. Springfield was concerned about the preemptive issue. But I think maybe the discussion was that we'll probably be okay with this verbiage. I see a legal head nod. That means yes, I think.
Mr. Chairman, after review of this, I do believe that it would not, in my opinion, which is not from the official opinion of OCD, obviously, but it would not be preemptive with their structures, regulatory issues. This section 6.12 of the third draft.
Commissioner,
I'm just curious, with the county commission, knowing that we deal with just land use,
Yes.
and then they wanted us now to deal with water quality and water, is that, I mean,
That is not, I understand that was what was written in that document. I am not convinced that the county commission wants to get involved in water issues or in drilling issues, either one of the two. I believe this language gives this body, when you're doing a conditional use, your ability to do your due diligence on what's happening with the water. Now, if this is the ordinance that goes up to the county commission, I'm sure that's gonna be an issue that will be discussed. And they're the policy makers. We're the implementers. We're the enforcers, both of us, staff and the planning commission. They are the ones who set the policy. They're the ones who are gonna make the determination whether or not they want the county to get knee-deep into water and drilling. I'm not getting that sense.
as far as I can tell, fellas, map number 2 could potentially work.
May I speak to that?
Certainly.
If you superimpose map number 2 on this map right here, it basically cuts down this way. It includes most of District B, District C. This area out in here has large tribal ownership out here. Laguna's out here. They're going to take care of their own jurisdiction. We're not going to get involved in that. You can see you have some private areas out here and private areas out here. That is way on the other side of the Puerco. You're getting closer to grants, that kind of stuff when you get out there. Let me explain the permissive conditional real quick. Permissive conditional for us is a good administration for processing of permits. If we do something here administratively, it can be appealed to you. But what it does is it requires that the applicant for an appeal identify where we messed up. So rather than you having to hear a de novo case, a brand new case, and you have to hear all this stuff, it could be spaghetti on the wall that's thrown at you. It forces the applicant to identify where they said the staff messed up, and then it's heard at this body, and you get to decide whether or not we messed up. Same with a conditional use. This body does a conditional use. So if somebody's to apply for an appeal, it would go to the county commission. But what it does, again, is it forces the applicant to identify how the planning commission messed up. So rather than them having to hear a whole nother de novo case, and they have to listen to all of whatever's thrown out there on the wall, it focuses the argument. So what it does is, from an administration point of view, it focuses the argument that basically is going to be used against the county in court. And it allows the county commission to be the final word on that issue. It's good from an administrative point of view. It's simple, it's easy, and it's clear.
Mr. Chairman, just a quick question for Michael before you run away from the map.
Yes, sir.
As I look at the Citizens Working Group map number 4, would it be accurate to say that District C is the area that we would consider where all the high population is?
Yes.
That's where those are?
Oh, yes. 80%, 85% of your population is in District C.
So I guess my question then is, and so I'm just throwing it out here so we can go to, because this is a working group meeting.
right,
I'm wondering if we take the Citizens Working Group map there and combine District A and B, what is the risk there in District B for, if we combined A and B and we made that permissive, and then C became conditional. What risk are we assuming
You
there?
still have communities within there. You have communities of concern. You have Peña Blanca and Sea Lake. You have Cochise. You do have those communities that would not be covered. And we are firm believers that this map does provide that protection for the populated areas. You can look on your map and you can look at all the communities that are in this red area, and it's almost all, except of course for Cuba, which I'm hearing two different stories because I get different phone calls and I get different people telling me that the Cuba area supports this. I'm telling you what I'm hearing. And that comes from the mayor, the past mayor. I have not talked to the current mayor, prominent business people in the community. I've been told how the economy is affected by this industry, and I'm being told that they do support it out there. That's what I'm being told.
Commissioners, what do you think about those two maps? We're getting down to the real specifics of things, where our recommendation is gonna have to be made. Map number 4, map number 2. Dallas, can I get some comment?
Mr. Commissioner, as I look at this, I see a lot of work that went into the citizens working group, and a lot of research. But we also want to make it easy to administer. So, and that's kind of where I was headed with combining districts A and B. But based on Mr. Springfield's comments, maybe there's some areas in District B that we name specifically, kind of point them out and make them conditional use only. I guess I'm just trying to move to where when we leave tonight, we have recommended to the staff a path to move forward for us next time, at least on the map. So we kind of split the county into at least 2 different conditional or permissive areas, and we've given them something to work with so they can have that prepared for us next time, so we can make a decision.
Okay, so let's move to this. Let's move to this. I think we've jumped on one thing, and then you'll be next. Promise. One thing that we've jumped over one, and what I would like to rectify now is I would like a motion that tells staff to make the block ordinance, or whatever it is, number 3, the block ordinance conditional use. Can I get a motion for that, please?
Mr. Chairman, a little confusing on that. Are you asking for a motion to direct staff to bring that to you to the next meeting with
Yes.
the necessary corrections and all the correct maps and everything like that for your consideration?
Yes. Discussion? Is that okay?
So, what you were asking was to make this just, conditional use, and that's not what the number 3 ordinance is, it's permissive and conditional use.
Right,
That's not what you said, I just wanted clarification on what you were looking for.
yeah, I want it to be permissive and conditional, and to clean up the language and clean up the maps, so that we'll have an actual draft that we can move forward with. So what I would like is a formal request by staff, to staff, to make the block ordinance permissive and conditional.
Or just to bring it to you for consideration?
For consideration, that's exactly what I want. Does you want to do it?
I'd like to hear Commissioner please.
Yes.
Comments before I make any comment.
I didn't want to direct my comments to what the chair was saying. I had something before that when we were talking about the maps. I think that dividing the county into districts has to have some rational basis. It has to be a reasoning process to get you to it, not just something that makes you feel good. Let's just split the county in half and do one half this way, one half the other way for the sake of convenience. For that reason, I think that we have to have rationally defined districts. One size fits all, I don't think is going to work in this county because of the great imbalance geologically and population-wise from east to west. As has been pointed out before, on the western side of the county, you've got virtually all of the economically productive oil and gas that we have in the county. It's a great potential source of revenue for the county and for the people who live there. And on the eastern side of the county, you have 90% of the population. You have the most dangerous, if that's the correct word, geological situation, most fragile geological situation, and the most at-risk water aquifer. So doing a one-size-fits-all, I don't think will work. If you made it all permissive, which is something the county commission already rejected in January, you put the people in the eastern part of the county at high risk, and New Mexico Tech indicated that already to us. And while you make it easy to develop oil and gas in the western part of the county. So I don't think the one size fits all works. You could go with 2 or 3 districts. 4 is not necessary. You could go with 2 or 3, but I think it makes more sense to go with 3 for several reasons. One is, if you look at the maps in the New Mexico Tech report, you find that New Mexico Tech divides the county up into 3 basic zones. The western zone, which is the San Juan Basin, the central area between, say, Cuba and San Ysidro, which is a transition zone, and then the eastern side of the county, which is the Middle Rio Grande Basin or the Albuquerque Basin. So for that reason, it makes sense to divide the county into 3 districts. And by doing that, you can then provide a maximum amount of protection where the protection is needed, but you can also encourage development of oil and gas properties where there are economically developable oil and gas properties. And let me bring that down to specifics. The county commission wanted aquifer protection. The place where we need aquifer protection is where 90% of the people in the county live. It's here in the eastern part of the county. And you can protect those people by creating a higher standard for oil and gas development in this part of the county. That's why in our draft, we made it a special use area. The other citizens working group made it a conditional use area. But those are certainly higher standards than just a permissive use. So I think that clearly with 3 districts, you can provide the maximum protection in the eastern part of the county. Now what about the rest of the county? You could, as I said earlier, use 2 districts, but 3 make more sense because, as I said, the New Mexico Tech kind of divides the county that way. And also because I believe that the San Juan Basin part of the county and the transition zone between Cuba and San Ysidro are different, both geologically and economically. They're different geologically because we know in the San Juan Basin there's a stable geologic situation. They produce oil and gas in the San Juan Basin for well over 50 years. There are more than 40,000 wells already in the San Juan Basin, not in the Sandoval County portion of the basin, but certainly over the entire basin. We know there's economically producible oil and gas there, And we know from over 50 years of production there that there's very little danger to aquifers. When you compare that with the transition zone, New Mexico Tech describes it as a frontier area which has never been explored for oil and gas and never been developed for oil and gas. So we don't know what's there, and we don't know what the potential danger to aquifers are there. So there is a distinction between those two geologically. There's also a distinction economically. I believe the people who live in the western part of the county, west of Cuba, rely upon oil and gas revenues and would like to have more. I think those people deserve to have the benefit of that. If we get more drilling there will be more jobs for them, there will be more revenue in that part of the county. So I think, as a policy matter, we as a county would want to make oil and gas development in that part of the county as easy as possible. And that's why our citizen working group made that essentially a modified permissive use. Now, the people in the transition area are in a different situation. They don't have the known oil and gas production. They're not relying on it. Those people, as I understand it, are agriculturalists. They do small farming. They graze livestock. And for those people, an assured water supply is a must. Otherwise, their cattle and their sheep are going to die. So I would think those people would want more protection than is allowed in the San Juan Basin. Therefore, we created that as a transition zone in our draft and made the process slightly more difficult than in the San Juan Basin by creating a conditional use there, but not as difficult as in the eastern part of the county, the middle Rio Grande Basin. So that was our rationale for 3 districts.
Okay, question. Was that based on that middle district, or was that based on a lack of history? Also, was that the primary reason, or?
Well, I wouldn't say it was.
Information.
I wouldn't say it was primary, Commissioner. I would say it was a consideration, because when you don't know where the aquifers are or where oil and gas is in relation to those aquifers in that zone, then you probably want to look at an application for drilling a little more closely than you would in the San Juan Basin.
My question, how difficult would it be to administer map 4 as opposed to map 2?
Well, what it does is it provides for a harder process for the applicant, harder process for the county. The logic behind it, I would argue. By the way, the red area is past San Ysidro going west. I hope everybody knows the county. There's not much out there. If anybody knows people in San Luis, I do, or Cabazon, I do, they would take any business. They would look forward to any business. They would look forward to royalties. They would look forward to anything that produces economic development. We're not using that as a legal, rational basis for regulatory control. What we're using is the boundaries as identified by the USGS. I think that as aquifer boundaries, as identified by the USGS, I mean, our attorney is here. I mean, I think that's an easy one to argue, that we use that as a rational basis. And at the same time, it just so happens that most of our population lives in the red area. That's the rational basis. We're only talking, if you apply the second map to the third map, we're talking about that very far area down in here. That would be permissive. I can tell you, we meet with these people from time to time. I know these people. We've talked to them over the years. They will take anything. If you want to talk economic development, you want to talk about jobs, these people out here are hungry for jobs, they're hungry for royalties, they're hungry for economic development. But we just think this map here is easily justifiable. It's split by aquifers as identified by the USGS. You can't get more definitive than that. I mean, it's the federal government telling us what it is. We're just following what they say. It takes in most of this area here, area B and C. Now, it's how do you administer, I'll be blunt, it's how do you administer an application. You can make it as bureaucratic as you want. You can use 3, and what it does is it makes it bureaucratic. It makes you go through all these steps. This body, if the county commission agrees, I believe, to be the best body to hear these applications. You have the language that you need in a conditional use to make sure that there is protection of water. It doesn't have to be so specific. I mean, you talk about write a law for everybody. You try and write laws that are open-ended enough so that you can deal with each case that comes before you. You don't try and write ordinances up front that try and guess what the situation is going to be, and then you're going to write a law for it. That's very hard for staff to administer language like that. Language like this that's in this ordinance gives you the ability to ensure that all proper steps are being taken to avoid pollution of water, surface water, groundwater. That's the kind of language you need to process a conditional use. Again, the 2 reasons for conditional use is it focuses the argument, especially when it gets up to the county commission. The county commission, once it gets an appeal, is assured that everything else has been covered, except for whatever it is that's being appealed. They can focus their time and effort on that specific issue or issues. It's just better administration of government law from our community.
Mr. Chairman, Mr. Springfield, thank you for clarifying that on the maps. It's pretty hard to see that on what we have here and looking over there. So that was very helpful. And when they do go for a permit with OCD, don't they also have to go through, they're checking for aquifers, they're checking for water, they're checking for,
Yes, they
I
do.
mean, we've gone through this over and over, so.
Well, they're the specialists who do it. They're the ones who are given the responsibility from the state of New Mexico to regulate it.
And this will give us the latitude to double check them as we move forward.
Correct.
If we have issues or if somebody in that area has a concern,
You
correct?
have to have those permits prior to coming to applying to the county.
Thank you for that clarity.
Mr. Chairman, if I could, the one thing I like about the wording, and I guess we'll call it number 3, is the fact that it does add some additional information that's available to the public for in regards to water, because I'm sure OCD takes care of this as far as their regulatory thing, but what it really does is it answers a lot of questions that I heard the citizens asking when we were going through this. I've only been 2 years almost. So it really addresses a lot of questions like how much water, what type of water are you using, where are you planning to get your water from, making sure they're doing reasonable measures to avoid pollution with surface water, groundwater.
Where's the wastewater?
Right, that all that is having to be accounted for, and it is documented somewhere. And so I really like that wording, and I think that, and I'll leave it at the rest of the commissioners what their thoughts are, but I think that meets the intent of what the county commissioners tasked us with, and within the realm that we're allowed to do, without preemption.
Correct. Mr. Chairman, if I may, when we as zoning people read language, for example, that says, provide proof. Okay, it's impossible. You can't do it. You can't prove that you're not going to pollute. You can't do it. It's impossible. You could argue that all day long, but using words like that is very difficult from an administrator's point of view. I don't know what legal would say about that. And those are words that you do not put into ordinances like that. Reasonable is reasonable. If you feel comfortable that all measures have been taken place, you're still going to have people that disagree with you, that you didn't do your job right. That's appealable. You know, you're trying to write a reasonable law to regulate the land use. Trying to write laws that take care of every single little thing that could ever possibly happen is from our point of view, the wrong way about doing regulation. You write the big main things. I can tell you zoning ordinances. We all know this. The commissioner knows, he's been on here long enough. Things happen. Things happen that you never knew was going to happen. That's when you go into a zoning ordinance and you amend it. You change it. You take care of that situation. That's just normal. That's the normal process that you go through in planning and zoning.
So, does anybody have any questions? What do you need from us?
I need a motion, if I may, to direct staff to amend Ordinance 3 based on map 2. Present it to the Planning and Zoning Commission for consideration and recommendation to the County Commission.
Can I get a motion?
So moved.
Seconded.
Is that a violation of open meetings?
They're directing staff, they're not taking final
You're
action.
taking a motion, which is a final action. This is in violation of the open meetings.
Mr. Chair, your agenda here says that there will be a discussion and recommendation. And so you can make a recommendation as to what you would like staff to do to consider for final action as a vote on adopting something. So you can take a discussion and recommendation. I would say that a motion for a recommendation for staff would be appropriate under your agenda.
That's what I understand it. All we're doing is asking staff to clean it up so that we can get the exact wording and move on to a next level, if that's something that we want to do. That's the way I understand it. Is that-
And I would just ask that you clarify that your motion is requesting for a recommendation for staff to do as you direct.
It was already,
That was my understanding as well. We were asking them to give us a recommendation, not an approval at this time.
I agree.
And just for point of clarification, we haven't decided.
We haven't decided.
We're going to definitely be discussing everything.
There's still five ordinances out there.
Because we have this wonderful spreadsheet here,
Just one of them, yeah.
and as we look at the wording that the staff comes up with, we can consider all the different things, and if there's anything we want to add, subtract, whatever, we can have those conversations.
Yes, as far as I understand, all we're doing is asking staff to clean up the wording on that ordinance. And that's the way I understand it. So the motion has been done. We have a motion and
With
a
that
second.
considers, I'll second.
All in favor, could you take the vote? This one, yours? I mean, the roll call.
Commissioner Stamp,
Yes.
Commissioner Day,
It was my understanding that the county commission directed the planning and zoning commission to consider an ordinance created by the Citizens Working Group. This proposed ordinance is created now by either Commissioner Block or planning and zoning staff, or a combination of the two. But it isn't what we were directed to do by the county commission, and I vote no.
Commissioner Medina,
Yeah, I vote in favor of it to move it along. I agree with the commissioner that just spoke. However, for the sake of this making progress, and the staff feels strong that number 3 has some meat into it, that we need to clean clean up and look at, I'm willing to do that, along with reviewing more and bringing about maybe the other 3 ordinances to come up with one final. Okay? That's the way I'm personally doing it. So I do okay.
Commissioner Stoddard?
Yes.
Commissioner Brown?
Yes.
Commissioner Herrera?
For the record, I want to make sure that I let everyone know that I agree with both Commissioner Romero and Commissioner Dang. All I want to do is just clear up wording to make it easier for us to move forward without any recommendation or without any, I'm not recommending, or I'm not putting any favor on any one ordinance. I just want to see wording that is cleared up. So my vote is yes. Mr. Swinfield, anything else that you would like the commission to move forward with?
No, sir. I'll send out an email to you guys. That's all we have, Mr. Chairman. We'll send you an email, Mr. Chairman. It's clerical stuff on cases and stuff like that when you schedule.
Any other comment from the commissioners?
Commissioner, just so you know, I possibly might not be at the next meeting, so I'll keep you posted and I'll keep staff posted to let you know.
Will you be able to forward?
I'm not sure, but I'll do the best I can, thank you.
Any other comment from any of the commissioners?
Mr. Chairman, if I could. One thing I would ask the staff as you go through and we take number 3 and we start to build it, I mean, you went to the trouble of analyzing all these other ordinances. If something makes sense to you, let's go ahead and roll that in to this ordinance, if it makes sense. If it's something that we have some legal issues with, then obviously, that's something we need to consider later. But if it's, some of the wording is very similar to what the citizens came up with, I think we should consider that definitely when we're, as we move forward. Sure, that'll probably help us as we move forward. Because I do not want to even give the impression that we're minimizing all the work that the citizen working group has done. Because I think they have done a lot of work here. And I think it definitely needs to be considered. The things that we can't do, we can't do. But the things we can, I think we should definitely consider.
Yes, sir. You have all that language before you, topic by topic, and you can go down and you can look at that language. There are some things we've seen inside the Citizens Working Group that we think might be able to fit in, that fits into the type of ordinance that's been. Like there's nothing wrong, for example, to do a historical review report. That's easy enough to do. I mean, you go to SHPO, you look at the register, you give us a report of any cultural that pop up on the property or something like that. That's something that fits into something like this. There are issues like that we can discuss. The good thing about putting it on the next meeting for consideration is now you can let the public speak. You can get input from other people into the process, and I think that will help. I would ask that the various groups and public, when they do, I mean, it's easy just to say, I'm against fracking or I'm against oil or something like that. Make it productive to this ordinance and bring your comments to this ordinance. I think that will help the process. I want to be just clear on what the commissioner just said. I understand that. The county commission had set up a citizens working group, but even that process went awry. Then it split into 2 groups. They didn't create two groups. They created one group, but we got two groups, we got two different ordinances, so I guess it goes both ways. I mean, we're trying to make sense out of this process ourselves, Mr. Chairman.
As far as I understand, we're gonna be, meeting on the 28th and also on the 11th.
You have a meeting on the 28th, which is a regular meeting. You will have a bed and breakfast case on that. So what we'll have is a regular agenda, but you're gonna have a case before you can consider the zoning issue or this ordinance issue. So that's gonna be a regular meeting. As I understand, since you bring it up, Mr. Chairman, the 11th of September is problematic on the date.
Yeah, it's.
So we
One of
might-
the best days of the year.
Yes, I understand that. And so possibly the 10th, which is a Monday, would work better. I'm asking the question.
It works fine for me, if it works for the rest of the commission.
Works for me.
We would recommend that we do it on the 10th if we have to. We may not have to. We may, I'm just throwing it out there.
Why don't we change it to the 10th?
Yes, if we could, Mr.
Do
Chairman.
we need a motion for that?
You can change it.
You can change it, Chair.
As the chair, on one of the best days of the year, I think we're gonna move our meeting from the 11th to the 10th at 4:30. Any other comments? Commissioner? Can I get a motion to adjourn?
So moved.
Seconded.
Second.
All in favor?
Aye. Mike, I'm sorry, I forgot to ask you this before, but I assume this version that we'll be looking at, posted on the website, so the public know.
Yeah.
I just wanna make sure because we'll discuss that.
We would just do exactly like this. Because we have to go section by section by section.